We are live now. Usually you can start.
Good afternoon, everyone. I, Bijal Ahuja, BBA third year student, on behalf of Bharati Vidyapeeth Deemed to be University, New Law College, Pune, Environment Cell, welcome you all to virtual symposium on procedural confrontation and the mastery of environmental law practice. I, Honorable Advocate Saurabh Kulkarni, sir, President at NGT Bar Association, Western Zone, Pune, Dr. Bhagyashree Deshpande, ma'am, Principal at New Law College, Pune, faculty members, and all the participants. Now, I will be inviting our esteemed Principal, ma'am, who is always a source of inspiration for us to address the gathering.
Yes. Thank you, Bijal. Good evening, everyone, for this wonderful webinar which we are going to have. Our founder, Honorable Dr. Patangrao Kadam, has founded the Bharati Vidyapeeth Deemed to be University. Our beloved Chancellor, Honorable Dr. Shivaji Rao Kadam, and our Pro-Vice Chancellor and Secretary, Honorable Vishwajit Kadam, who is also the Minister of Maharashtra State for the Social Justice, have always guided us. Bharati Vidyapeeth Deemed to be University is a class of its own and has been ranked 63rd by the NRF. The New Law College is known for its innovative ideas and is consistently ranked among the top 10 law colleges in India. Today's webinar has been organized by the Environment Cell, Bharati Vidyapeeth New Law College. The motive of this particular webinar is to make the society as well as the budding lawyers to be aware of the NGT practice. Environment protection is a very global, vital, and intricate issue. So, through the Environment Cell, the New Law College students, along with the coordinators and the other faculties, try to bring awareness for the environment protection. And one important aspect is the NGT practice. So today we have invited the eminent scholar, Advocate Kulkarni, who is going to help us to know all the issues relating the NGT practice. So I hand over to you, Bijal, for the introduction. Thank you.
Thank you so much, ma'am. It gives me immense pleasure to introduce today's guest, Honorable Advocate Saurabh Kulkarni, sir. Sir has completed his law from one of the best universities in India, University of Pune in 2007, and did LLM in International Law, Commercial Law from University of Birmingham, UK in 2009. He submitted dissertation on takeover regulation, comparison of mandatory bid and equal opportunity codes, a thesis on takeover laws in UK, USA, Australia, and New Zealand. Sir has been awarded Diploma in Mergers, Acquisitions, and Takeovers and Diploma in Cyber Law by Asian School of Cyber Law, Pune, with special study on ATM crimes. He is a registered trademark attorney. He has appeared before various courts and tribunals all over India, that is National Green Tribunal, Pune and Delhi, High Court of Bombay, and Supreme Court of India. Environmental law, labor laws, industrial and service laws are his areas of specialty. Now, I request Sir to address the attendees.
Good evening to all of you. I thank the New Law College for giving me this opportunity to address on the core issue of the practice and procedure before the NGT. Now, coming to the topic for today evening, what was the need for India to set up the NGT? The issue starts with that India is a developing country and it's also a manufacturing hub. So with all these industrializations and all the expansion projects taking place in the country, there were certain environmental hazards which took place in the country. There were also certain environmental mishaps which took place in the country. So the famous cases which all of us who practice in the field of environmental law are aware about, the Bhopal gas tragedy and the oleum gas leak at Delhi. The said disasters we can call as were the man-made disasters, which led for the government to think that there should be a specific or a specialized environmental law to take care about the environmental hazards and also the equal protection of the environment in the country. Basically, the Bhopal gas tragedy, which took place in the year 1984, led to the leakage of the gas in the city of Bhopal, and which led to many lives being lost. So, in the background of the Bhopal gas tragedy case, there was another case which took place in Delhi in the year 1986, which was the oleum gas leak. And after these two major hazards, the government thought it fit to draft the Environment Protection Act, and that is how the Environment Protection Act came into existence in the year 1986. Now, if we see the basic applicability of the Environment Protection Act, it is applicable to all the projects which take place in the country. So under section 15 of the act, which is the most important section of the Environment Protection Act, there is a provision for the authorities to file a complaint under section 15 of the Environment Protection Act. Basically, such complaints are usually filed before the Chief Judicial Magistrate in the district. Secondly, under that act, if you are found to be a violator, you are imprisonment for a period of 5 years and a fine of 1 lakh or both. Now, under the Environment Protection Act, there are various rules which have been drafted from time to time and which have come into existence subsequently. There is the construction of demolition and waste rules. Then there is the plastic waste management rule. There are the solid waste management rules. There is the batteries protection rule. There is also the e-waste rules. There is also the biomedical waste rules, etc. So all these rules are forming the part of the Environment Protection Act. Now, under the Environment Protection Act, Section 5 is the important section which gives the ministry and the government authorities the power to issue directions from time to time. Now, shifting our focus from the Environment Protection Act, India is also a signatory to the United Nations conference which was held in the year 1992. In the said conference, India vowed to set up a tribunal to deal extensively and exclusively with the environmental issues. So, taking the path forward from the 1992 conference, the Constitution of India under Article 21, Article 21 also grants every citizen to have right to life, and under the right to life, each citizen must enjoy right to good air and right to good environment. So, taking the base of the Conference of the United Nations of 1992 and Article 21, the government decided to set up the National Green Tribunal Act, and the bill came into existence in the year 2009, which was subsequently discussed in Lok Sabha and Rajya Sabha, and the National Green Tribunal Act was passed in the year 2010. Now, coming to the tribunal, the constitution of the tribunal consists of equal number of judicial members and expert members. The judicial members are the retired judges of the High Court and the Supreme Court. The retired judge of the Supreme Court is basically the chairperson of the tribunal. And the expert members are who are having expertise in the field of science and environment, so that they can deal with the issues relating to the environment destruction and environment protection. India is first such country in the world to set up a tribunal consisting of members of the judicial and the expert background. There are also tribunals in Australia and New Zealand, but the tribunals there do not have the combination of an expert member or a judicial member. So the first bench was constituted at New Delhi, and it came into existence on 18th October 2010. And the objective of the central government to set up the National Green Tribunal was to provide a specialized forum for effective and speedy disposal of cases pertaining to environment protection, conservation of forests, and for seeking compensation for damages caused to people or property due to violation of environmental laws or conditions specified while. Sorry, I did not share the PPT. 1 minute, just yeah. Is everybody able to view this PPT?
Yes.
Yes. Okay. So basically, I was saying that the NGT was established on 18th October 2010 under the National Green Tribunal Act, and it was passed by the central government. The main objective of the central government was to provide a specialized forum for effective and speedy disposal of cases pertaining to the environment protection. Now, following the enactment of the said law, there were the length and the breadth of our country is such use that the courts are burdened with lots of cases. So the government thought it fit to establish benches at New Delhi, which is also the principal bench and deals and caters to the entire northern part of the country. The Western Bench, which is at Pune, which consists for the state, which deals with cases from states of Maharashtra, Gujarat, and Goa. Then Bhopal, which is the Central Bench, which caters to the states of Madhya Pradesh, Chhattisgarh, and Rajasthan. The Chennai is for the Southern Bench, which caters to states of Telangana, Andhra Pradesh, Kerala, Karnataka, Tamil Nadu. And Eastern Bench is for Kolkata, which caters to states like Bihar, Jharkhand, West Bengal, Odisha, and all the northeastern states. So these are the several regional benches which have been set up in the country. Pune was fortunate enough to have the bench established in the year 2013. The exact date is 25th of August 2013. And since then, we have been having cases going on before the Pune bench. There is also a mechanism to set up circuit benches, and circuit benches were set up for a certain amount of time. They were set up at Kochi for the south zone, at Jodhpur for the central zone, and Shimla for the northern zone. Now, before adverting to the issue of the NGT practice and procedure, I would like to highlight the core issue, what leads to basically the litigants approaching the NGT. The Ministry of Environment and Forest in the year 1994 came up with the Environmental Impact Assessment Notification. Under that notification, the ministry categorized certain activities which were essential for the project proponents to obtain a clearance from the ministry before commencing their activities. So, considering that there was a procedure given in the said notification that these activities required clearance from the ministry before setting up of their plants or before commencing their activities, and in that environment clearance, certain conditions were given to the project proponent to follow those conditions. The said notification was subsequently amended in the year 2006 with strictures passed where you had a time limit given, as in when the application is received by any ministry, they have to process it within the period of 60 days. Public hearing where there will be a impact upon the life of people upon setting up of the project was also introduced, and the activities were classified into categories A and categories B, and category B was subsequently divided into B1 and B2, and the categories of B2 were then dealt by the committee which was set up at state level. So the environmental clearance was granted under the said notification, and any breach of that notification, the breach of that clearance led to the parties approach the National Green Tribunal. Now, as I said that the chairperson of the NGT is a retired judge of the Supreme Court. At present, we have the Honorable Chairperson, Mr. Adarsh Kumar Goel. Then the judicial members are the retired judges of the High Court, and the expert member, as I said, needs to have a professional qualification of minimum 15 years in the field of environment and forest conservation and other related subjects. So the composition of the NGT is given under the section 4 of the NGT Act 2010. Under that section, it says that a case which has to be decided by the bench of the NGT, it needs to have equal number of judicial and equal number of expert members while deciding the case. The reason being that the environmental is a very technical subject and the judicial people lack knowledge regarding the technical issues, and that is where the role of the technical member is very essential, who helps in deciding and adjudicating the said case. Now, the NGT is basically a tribunal which is set up under the NGT Act, and there are no certain procedures which have been given under the NGT Act. So under section 19 of the NGT Act, the NGT is directed to follow the principles of Civil Procedure Code and the Indian Evidence Act. Now, in NGT, we do not have the procedure wherein a witness is called for and he is examined by the lawyers, and the same procedure which takes place under the trial under the CPC or CRPC. It is not followed by the NGT. However, there is a provision where you can appoint a committee of experts who can be directed to submit a report on a specific subject matter. And at present, the present regime of NGT is strictly following that procedure wherein the committees are appointed. The people are from the technical background from bodies such as NEERI, Central Pollution Control Board, IITs, etc. Now, there is a schedule given under the NGT Act, which is known as the Schedule 1. Under the Schedule 1, the following acts are mentioned as what you can see on your screen: the Water Prevention and Control of Pollution Act, the Water Prevention and Control of Pollution Cess Act, Forest Conservation Act, the Air Pollution Act, Environment Protection Act, which is, as I stated earlier, which is subdivided into various rules, the Public Liability Insurance Act, and the Biological Diversity Act. Now, these 7 acts are essential because if you have to file a case before the National Green Tribunal, the violation or any order which has arisen or passed in accordance to the said laws can only be entertained by the NGT. No other act which is outside the scope of the Schedule 1 can be entertained by the NGT. The reason being that the NGT is a creature of a statute, which is the NGT Act, and any expansion or deviance from the pleading from the said enactments can lead to ousting of the jurisdiction of the NGT. Now, coming to the next aspect, what is the procedure for filing an application, original application or an appeal before the NGT? Because this is the important aspect. This is the core aspect of the NGT Act as to how a case can be filed before the NGT. If you look at the NGT Act, there are 2 important provisions, which is Section 14 and Section 16. Now, these 2 sections give jurisdiction to the NGT to decide a case before it. Section 14, we can say, is the original jurisdiction. Under Section 14, if a litigant feels that there has been breach of any of the environmental laws under the Schedule 1, or breach of the environmental clearance or the consent granted by the authorities under the Water and the Air Act, he can very well approach the NGT by filing a petition, or which is called as the original application, under Section 14, by paying a stamp of, say, 1,000 rupees. And that cause which has led him to file that application before the NGT must have occurred 6 months prior to the filing of the present petition. So, the cause of action which leads the litigant to file the original application before the NGT must have accrued 6 months prior, and it has to be, the cause of action should have been first arisen. There is no process, or there is no, what you say, wording of continuous cause of action under the NGT Act. So under Section 14, which I said that it is an original jurisdiction to the NGT, the complaint has to be filed within 6 months from the date of accrual of the cause of action. However, there is a proviso given under the Section 14 that you have a period of 60 days where the tribunal can consider the delay, which can be condoned by filing a separate application for condonation of delay and by paying a stamp of 1,000 rupees, and the application can be filed. Now, under Section 14, the relief which can be claimed has to be coupled with Section 15 of the NGT Act. Now, Section 15 of the NGT Act provides for the provisions of restitution, remediation, restoration, and compensation. Now, if there has been pollution in a specific area, under Section 15, the NGT can direct that polluter to restitute the environment. To the authorities can be directed to give remediation measures, and also with the help of that remediation and restitution plan, there can be restoration of the environment if possible. Now, if on account of that pollution, the people or the residents in the said area have faced environmental hazards, then they are also liable to seek compensation. The compensation can be sought before this tribunal by filing a form which is known as Form 2, which can be seen in the NGT Act under Rule 8. Rule 8 of the Practice and Procedure Rules 2011, which is appended to the National Green Tribunal Act 2010. Under that Form 2, the victim has to give all the material particulars, as in his place of residence, what is the nature of accident which took place, what is the damage or loss caused to his personal property or to his family members, and if at all that claim has to be quantified, then how much it will come into the terms of rupees. Also, if any complaint has been lodged by him before any authorities or before the police authorities, and all those details along with these documents have to be submitted under the Form 2. Now, supposedly, consider for an example, if I am the victim of pollution and if I file a Section 15 application before the NGT and I claim that I am entitled to seek a compensation of rupees 5 lakhs. So when I say that I am entitled to receive a sum of rupees 5 lakhs, under the NGT rules for practice and procedure, I am also liable to pay 1% stamp duty before the NGT while making that application for compensation. So for 5 lakhs, I have to pay 1% stamp duty. Now coming to the second part of the jurisdiction of the NGT, it is the appellate jurisdiction. Now the appellate jurisdiction is mentioned under Section 16 of the NGT Act. Now this is a section wherein the appeals can be entertained by the NGT if there has been a rejection of the orders of the authorities under the statutes which have been mentioned under Schedule 1 of the NGT Act. Now taking for example the Water Pollution and Prevention Control Act of 1974 and the Air Prevention and Control of Pollution Act of 1981. Under these two statutes, the state pollution control boards grant consent to all the companies or to the activities which have to commence their operation within that state. Now, under Section 33A of the Water Act and 31A of the Air Act, there is a power given to these authorities to issue directions to those activities. Now, those directions can be in the nature of closure of that unit and also disconnection of the water and the electric supply. Now, suppose if I am in receipt of an order of closure under Section 33A of the Water Act, what would be my remedy? My remedy would be to approach the NGT under the provisions of Section 16 of the NGT Act and file an appeal before the NGT. Now, I have to file that appeal within a period of 30 days from the receipt of the order. So the moment I get the communication from that authority that this order has been served upon me, once that order has been served upon me, I have to prefer that appeal within 30 days. Now, as stated under Section 14, there is a period of 60 days which has been given to the tribunal to condone the delay. Also under Section 16, that delay can be condoned by the tribunal for a period of 60 days. Now, what are the orders which I can challenge before the NGT under Section 16? What can be an appealable order? So it can be a closure order issued under Section 33A of the Water Act, Section 5 of the Environment Protection Act. Then there is maybe a rejection of my application for environmental clearance, rejection of my application for grant of CRZ, coastal regulation, zonal permission, etc. Now, I would just like to highlight two issues before you all, two cases which have been dealt by the NGT. Now, while dealing with an appeal under Section 16, the NGT has to follow principles of natural justice. Now, what do you mean by natural justice? Is by, of course, hearing the aggrieved party, giving him sufficient opportunity for representing his case, and then passing a speaking order. Now, when I approach the NGT under Section 16, the NGT has dealt with, I would like to mention two cases out here. There is a case of Mr. Vajri Vel versus the Tamil Nadu Pollution Control Board, which was decided by the South Bench of the NGT. Now, this case, I would like to highlight two issues. The company had received a notice of closure under section 33A. Now the authority, that is the Tamil Nadu Pollution Control Board, while handing him over the closure order, did not follow the principles of natural justice. That is, they did not serve him a show cause notice, they did not give him adequate hearing, they did not examine the documents, and without following these principles, directly a closure order was issued to the company. Now, the Water Act and the Air Act have specific provisions imbibed in them, wherein under those acts, you have to give a notice in writing to the company 15 days. You have to give him a time to respond to that notice. You have to give him sufficient hearing, and without hearing, you cannot pass the order. And if the order is to be passed, it has to be a speaking order with justified reasons. Now, in this case, the NGT was pleased to hear his appeal. They held that the Tamil Nadu Pollution Control Board did not follow the principles of natural justice, and they laid down the ratio that if a company or an organization which has been enjoying a consent under the provisions of the Water and the Air Act, it has to be served upon a notice, and the principles of natural justice are to be followed. Now there was, and the appeal was allowed, and the closure order was quashed and set aside. Now there was another case which was considered by the principal bench at New Delhi, wherein the company known as CRM, the Uttar Pradesh Pollution Control Board had served them with a notice of closure. Now, while deciding this case, the honorable chairperson at that time, Justice Swatantra Kumar, was pleased to observe a very, different wording of the order. He stated that closure of an industry leads to civil death, as in once a closure order has been passed by the authority, it leads to civil death not only of the people who are working in the factory but also their family members. Hence, that power has to be exercised very judiciously. So when the authorities are issuing closure orders, it has to exercise its power very judiciously by following all principles and by seeing to all considered factors which are necessary for passing of that order. So while deciding the proceedings before the NGT has to follow three important principles which are stated in section 20 of the NGT Act, and they are principles of sustainable development, precautionary principle, and polluter pays. Sustainable development, as we all know, the development which has to be sustained by the environment today and in future. The precautionary principle is a very important rule and which the NGT also has to exercise it judicially. Suppose there is a project which is coming up and the NGT comes to an opinion that that project might cause environmental hazards in future, it can very well apply that rule and not grant permission for that project to come up. That is the precautionary principle. And polluter pays is, of course, the one who does the pollution has to pay the price for it, which may be into rupees, or maybe he has to restore the environment, restitute, or maybe remediate the environment. Now, there are also provisions of review and appeal mentioned in the NGT Act. Now, as I stated that NGT does not follow a specific procedure. It has to follow the principles of CPC. Under section 19 of the NGT Act, read with rule 22 of the NGT rules, one can seek a review of the order which the NGT has passed, and that review has to be filed within 30 days from the date of the order which has been passed. There is no specific provision given for delay condemnation under the NGT Act and the rules. Hence, the review has to be filed within a period of 30 days. Now, what if the person is aggrieved by the order of NGT? Under section 22 of the NGT Act, the order or the decision or the judgment of the NGT which has been passed is only appealable to the Supreme Court of India. So, order of the NGT which I am aggrieved of, I can only approach the Supreme Court by filing a civil appeal. That civil appeal will also have to be filed within a period of 90 days from the passing of the date of passing of the order. there the Supreme Court, of course, has the power to condone the delay if it is filed beyond the period of 90 days. So these are the important provisions, as I stated from the today's session, that section 14, section 15, section 16, section 19, and section 22, which are the core and important sections which a person has to consider while practicing before the NGT. Now, there are certain cases which I have listed today, which I would like to discuss before you, which are very important for a person while uh, he has to study these cases while approaching the NGT. The recent judgment of the NGT, which was passed in the year 2018 by the principal bench and led by the Honorable Chairperson Justice Adarsh Kumar Goel, was Shivpal Bhagat versus Union of India. Now, under this judgment, the NGT observed that if at all a litigant who has to approach the NGT must first file a representation or a complaint before an authority, and if the authority fails to take any action on the pollution which is being caused on the representation or the complaint made by the litigant, then after expiry of 15 days, that litigant can approach the NGT by filing an original application or an appeal, whatever as the case may be. So this judgment is very important in present circumstances while approaching the NGT, because this reference has to be given by that litigant. The other case which I would like to discuss is of Betty Alvarez versus the state of Goa, which was decided by our Pune bench. Under this case, the tribunal observed that a foreign national who is not a resident of this country can also approach the tribunal and point out the environmental pollution which is going on in the state or in the place where she is visiting. The case of Almitra Patel versus Union of India, under this case, the NGT observed that burning of waste in open areas is prohibited. So there was a fine which has to be imposed of 5,000 rupees if the violation is observed by the authorities on immediate effect. The other case of the principal bench is Shailendra Singh versus Union of India. Now this case is very important because it deals with the groundwater. Now when we have the monsoon season and when the groundwater is percolated, under this decision, the NGT mandated that any commercial establishment who is going to extract the water, the groundwater for commercial purposes, has to obtain the no objection certificate of the Central Groundwater Authority. Without that permission, the establishment will not be permitted to operate and conduct their activities. Now, there was further amendment to this order where the NGT has now passed certain strictures. It says that the commercial establishment seeking NOC of the CGW, that is the Central Groundwater Authority, must also submit an EIA, which is known as the Environment Impact Assessment. So they have to give an environmental plan as to how they are going to utilize that groundwater. Now, there is a case of Aryavrat Foundation versus State of Gujarat. Under this decision, there was a lot of issues pertaining to pollution pertaining to the city of Vapi. Now, under this judgment, the NGT observed that the common effluent treatment plants, which is a requisite for all the small scale and the medium scale industries during their operation, was not functioning as per the environmental standards. So they categorized industries into three categories, such as small scale, medium scale, and large scale. And they imposed fine on those industries for causing pollution. So small scale industry was directed to deposit an amount of rupees 25 lakhs. Medium scale industry was directed to deposit an amount of 50 lakhs. And large scale industry was directed to deposit an amount of rupees 1 crore. So that terminology used was the environment compensation. Now, environment compensation terminology has been observed by the NGT in the judgment of Paryavaran Suraksha Manch versus Union of India. Now, this Paryavaran Suraksha Manch case was initially decided by the Honorable Supreme Court, wherein they had observed that the CETPs or the effluent treatment plants which are used by the industries all over the country are not meeting the standards as prescribed under the Environment Protection Act and the EIA notification. So they directed that the authorities draw up an action plan, how these plans can be made effective and in accordance with the provisions of the law. So they transferred the case to the NGT for execution of its order. And the NGT, by calling a report from the Central Pollution Control Board and the Ministry, decided the case and formulated a terminology called as environmental compensation. Now, that compensation is decided on the basis of factors such as, well, what is the location of the company, the population which has been affected, then what is the category of the industry, whether it is a red category that is highly polluting, whether it is an orange category moderately polluting, a green category which is not polluting at all, and white category which is not a non-pollutant company. So depending upon the category of the company, also the number of days which it has caused the violation. So on the basis of this formula, the industries are imposed upon the environmental compensation. Now, in the recent past, the NGT has also decided to take cognizance of certain issues suo moto, by taking cognizance of the articles from the newspapers and passing directions which have to be implemented throughout the country. Now, I would not discuss more on the issues which are taken up by the NGT on suo moto basis, because that issue is for consideration before the Honorable Supreme Court, whether the NGT has the power to discuss the issue suo moto or not. The Supreme Court has also, in the recent past, heard certain appeals arising out of the orders passed by the NGT. The certain aspects which I would like to discuss before you are the Sterlite case, which had the Sterlite company, which had filed the appeal before the Supreme Court pertaining to the closure order issued by the Tamil Nadu Pollution Control Board. The Supreme Court observed that when a company has been served with a closure order under the dual provisions of the Water Act and the Air Act, it has to file a writ petition before the High Court, and they cannot directly file an appeal before the NGT. The reason for that is the provision under the Water Act, that is Section 33A, gives power to the State Pollution Control Board to pass directions. And that order under Section 33A is appealable to the NGT directly. Whereas under the Air Act, when an order is passed under Section 31A of the Air Act issuing directions, that is appealable only before an appellate authority of the state. And after the appellate authority gives a decision, then that order can be challenged before the NGT. So there are two conflicting provisions. So a combined order passed under both the statutes, the NGT will not have jurisdiction, and only a High Court can entertain a writ petition under Article 226. Then the other case is of the Federation of Rainbow Warriors versus Union of India. Now this case pertains to the new airport coming up in the state of Goa, which is known as the Mopa Airport. Now certain NGOs had filed an original application before the NGT, and they had challenged the destruction of the environment which was taking place on the said site, and that while challenging the environmental clearance, there was no public hearing which had taken place, and that is why these people had challenged the environmental clearance before the NGT. The NGT had initially stayed the environmental clearance, but after subsequent reports from the government authorities, that case was decided, and then the NGOs, being dissatisfied with the judgment of the NGT, filed an appeal before the Honorable Supreme Court. The Honorable Supreme Court in the said judgment observed and laid down the importance of the public hearing. It said that when a project of such vast implications is to come up, the public hearing was essential. And that is why the environment clearance was suspended for a certain period of time, and a further report was called from the authorities. In the said judgment, the Honorable Supreme Court has also observed the importance of the role of the expert member who is party to the proceedings and who is a member while deciding and adjudicating the cases. The expert member also has to give his view or his opinion while deciding the case before it. The other case was of the Ambelic Pharmaceuticals versus Union of India. Now, under this case, the Supreme Court was pleased to observe that under the environmental jurisprudence, there is no provision to grant a post facto environmental clearance. That is, if a project which has commenced without obtaining an environmental clearance from the authorities, it cannot thereafter apply for an environmental clearance and the authorities grant a post facto environmental clearance. Now, this issue is the question of debate under the new notification which the government proposed to get under the EI notification 2020. Still, it is at draft stage, so it's not better to discuss about it. Now, there are certain frequently asked questions regarding what is the difference between a court and a tribunal. Now, this issue has been decided by the Supreme Court, where every court may be a tribunal, but every tribunal necessarily may not be a court. So, as stated that the NGT has limited powers, as it has to only, but it is bound by the NGT Act. It cannot expand its scope, and it cannot go beyond the scope of that act. So the powers which an NGT can exercise are only as per the powers mentioned under the NGT Act. So it is a creature of a statute, and it has to go by that statute. The second question is, like, taking an example, that there are certain issues which we hear nowadays, that if we are trying to protect a national park or a sanctuary from various pressures, including for a dam project or a widening of a highway, can you approach the NGT? The answer is no, because NGT is not empowered to hear matters pertaining to issues coming under the ambit of Wildlife Protection Act. It can only hear disputes which pertain to the acts and enactments mentioned in Schedule 1 of the NGT Act. Whether a person can personally argue the case before the NGT. Yes, the person can personally argue a case before the NGT, and he is not required to engage a lawyer before the NGT. Now, in view of the COVID pandemic, the NGT was the first tribunal in the country to start the provision of filing the cases online. So a person who is maybe residing in, say, a remote place in the state of, maybe say, Jammu and Kashmir, in the Union Territory of Jammu and Kashmir, and wishes to file a case at Delhi, he can file the petition online, and there is an option mentioned before him that whether he wants to argue it in person or maybe his case decided in his absence. So NGT was the first tribunal in the country to entertain online applications and also conduct cases through video conferencing. Whether there is a penalty for any non-compliance of an NGT order. Yes, under section 26, the NGT has a power to issue directions if there has been a non-compliance of its order, and it can be extending up to 3 years or fine which may extend to 10 crores or both. And continued failure will also attract a fine of rupees 25,000 per day. Is there a bar on civil courts to hear or take up cases under the 7 specified laws of Schedule 1? Yes, the enactment of the NGT, under the enactment of the NGT Act, that is more specifically section 29, civil courts cannot hear matters which are related to environmental issues under the laws which are mentioned in Schedule 1 of the NGT Act. Now, various states have also enacted certain laws which can preserve the environment, such as the Tree Felling Act. In Maharashtra, we have the Tree Felling Act, wherein the power is given to the local municipal corporation to protect the trees or grant permission under the said act for tree cutting. Now, these issues have time and again come up before the NGT, whether the tree cutting issue or the tree felling issue can be part of a case before the NGT, or will it be part of the state act and will it go before the civil court? Now, if we see the definition of the environment, which has been given under the NGT Act. Now, the definition of environment under the NGT Act is very clear. It says that environment includes water, air, and land, and the interrelationship which exists among and between water, air, and land and human beings and other living creatures such as plants, microorganisms, and property. So, the NGT has decided many issues pertaining to the tree felling, and they have entertained those original applications as well. So that is it. Thank you for your patient hearing. Any questions, you may let me know.
Thank you so much, sir, for such an informative session. Sir, we have received few questions by participants. May I ask?
Yes, please.
So, as the president of NGT Bar Association, so how do you look forward to associate with more and more students with the NGT so that environment law practice is a sought after stream by the future advocates of this country?
See, basically now it is an upcoming area of law, and where because of constitution of benches in the country, people are ready to take up these issues, because please understand that the stakes involved in these cases are very high. So I would urge the students to take up this field of law as well, because now it is the need of the hour, and there is a lot of topics where a student can do research and take up cases, because what is the role of NGT is yet to reach in the nook and corner of that country. So we are thinking of organizing such webinars wherein we can pass on the message, and the what is the exact role of the NGT can be explained to the people, the common man, as well as to the young lawyers who are likely to take up practice before the NGT.
Thank you, sir. Which are the government authorities concerned with cases at NGT?
I'm sorry, I didn't hear you properly.
Are the government authorities concerned with cases at NGT?
Yes, yes, they are very much concerned, because ultimately, if any case which has to be filed before the NGT, the government is the party. And as I stated in my session just now, that if there is a non-compliance on part of any of the authorities by the order of the NGT, they are liable to pay fine. I may just cite one example. In one of the case which I am dealing, it pertains to the pollution at Taloja in Navi Mumbai, wherein the authorities such as MIDC and MPCB failed to comply with the order of the NGT. The NGT observed that the main officers, that is the chairperson of the MPCB and also the managing director of the MIDC, they were directed to comply with the order within a period of 1 month. If they don't comply with the order within a period of 1 month, the NGT passed the direction that they should be replaced. And if they fail to comply, their salaries also should be attached. So the government authorities are now quite becoming serious about cases before the NGT.
So, taking into account the actual strength of bench versus the sanctioned strength of the bench, on what has been the effect of working of NGT when these major number of seats are vacant, as per your opinion?
The issue is quite hot at this point of time, because the sanction state under the NGT Act says that there should be 10 judicial members, 10 expert members, and one chairperson. And currently, the NGT is functioning with one chairperson, three judicial members, and three expert members. So the issue relating to appointment of members is sub judice before the Supreme Court. I, as a president, and with the committee members of the NGT Bar Association for the Western Zone, we have filed a case before the Supreme Court, and the appointments process is under consideration. Maybe from January 2021, we'll have all the benches in the country functioning. At present, there are only the hearings are only taking place through video conferencing, and that is also from Delhi.
Okay, sir. So, how do you perceive the role played by the NGT, particularly with regard to Sustainable Development Goals 13, 14, and 15, especially when it lacks the requisite bench strength and that its penal powers seem to be limited in view of it being only a tribunal?
See, it may have a limited power, but the power which it has its effects, because the NGT has been quite vocal, and it has been quite impactful considering the new projects which are coming up nowadays. Because as I stated, there are various cases where the NGT has held not only the project proponents but the government authorities also responsible for causing pollution. So now, if any permission which has been accorded to any of the project proponents or to any person who is setting up new projects, it is passed with certain strictures, and also with considering the latest ratios laid down by the NGT. So the role of the NGT is quite important, because we have to understand that the NGT was created with the sole purpose that the high courts and the Supreme Court in the country were burdened with environmental issues. And unfortunately, they did not have the expertise in the field of environment. And now, with coupled with the combination of the judicial member and the expert member, it definitely helps the tribunal to decide the case. And under the NGT Act, the case has to be decided within a period of 6 months. And now with the authorities filing their reports on time, the cases are decided in short duration.
Okay, sir. Indeed. River encroachments and wetland destruction continue unabated in spite of several regulations made by the entity in several cases, some which you rightfully mentioned in your enlightening presentation. So, what kind of measure do you suggest that such illegitimate practices finally end?
See, for that to happen, more and more people have to approach the NGT and point out the violations which take place, because we have to deal it with case to case basis. Now, I would just cite an example in the city of Pune, where the municipal corporation intended to set up a road along the river bed. Now, that issue was taken up by the environmentalists in the city of Pune, and it ultimately got settled in the Supreme Court. So the issue was whether the river bed should have a road along its side, and that road was subsequently directed to be demolished because it was ultimately stopping the flow of the river. So the NGT in its order observed that if at all the corporation intends to construct the road, it has to be on the pillars, and it has to also take measures that the flow of the water does not stop. So, regarding these issues about wetland encroachment and river encroachments, that person has to approach the authorities, and if not the authorities who fail to take any action, then they have to come before the NGT, because the NGT is passing directions day in, day out. Now, it is up to the authorities to implement, and if the authorities don't implement, we also have the provision to file execution before the NGT. It all again depends on case to case basis.
Sure, sir. So, despite of several judgments and fines on pollution as well as environmental protection, including recent 113 crore fine on Jharkhand government for lapses that took place during past time of government, what all amendments are required in NGT Act to address such environment lapses before its large-scale impact?
The amendments, if you ask me, that there are certain more enactments which needs to be included in the schedule, because the issues relating to mining are not part of the NGT Act. Now, mining or pertaining to the coal blocks allotment, or there are various other issues like the Wildlife Protection Act is also not part of the NGT Act. So there are certain enactments which have been left out of the Schedule 1 of the NGT Act, which needs to be brought in. But again, it's a question of debate which the Parliament has to take up. So if you ask me the amendment, maybe the time limit for filing the case should be increased from 6 months to maybe a year or maybe 2 years. These are certain amendments which we feel should be thought upon by the government.
Thank you, sir. Thank you so much for answering all the questions. Now, on behalf of Environment Cell, Bharati Vidyapeeth deemed to be University, New Law College, Pune, and the entire fraternity of the institution, I would like to express my sincere thanks to Honorable Advocate Saurabh Kulkarni, sir, for gracing the occasion and sharing with us his thought-provoking opinions on practice and procedure at National Green Tribunal, and explained us the structure and detailed functioning of entity through the act and the cases. I would like to express my deep gratitude to our beloved principal, ma'am, Dr. Bhageshri Deshpande, ma'am, for her constant motivation and enthusiastic support in organizing this event. I would like to thank Dr. Jyoti Dharma, ma'am, Head of Environment Cell, for her guidance and moral support, and Dr. Jayashree Khandare, ma'am, Faculty Coordinator, who have been the pillars of strength for our environment cell and actively guided us throughout. I am happy to express my thanks to our staff members and the participants for making today's event successful. And last but not the least, I would like to thank our technical team. Thank you so much, one and all.